but you have also dropped 377, which means that if a man without his consent is subjected to that kind of offense, then today where is the window to ventilate the grievance? There is none. And that, to my mind, is completely an incorrect idea. Because consider it this way, that if the child, a male child, is below 18, then POCSO Act applies. So therefore you can still sort of, reach the accused through another way, which is another legislation, which is POCSO. But POCSO does not apply where victims are more than 18. Now what if the victim is more than 18? 377 is gone. And that, to my mind, is one perhaps, shortcoming in this entire legislation. Otherwise, everything is, at least, seems to be going in the right direction. But this, perhaps, I think, overreaction, we have not only thrown the baby, along with the bathwater, we have thrown the baby as well. So therefore, we have lost the opportunity and made it completely a vacant idea where there is no grievance can be ventilated by a person who is a victim of that kind of crime. Otherwise, to my mind, this new legislation in certain areas has bodily lifted sections. Even the chapters are also sort of, with the chapter nomenclature, the heading are taken out and rearranged. So normally our principles have always been that we say offense against the state, offense against the human body, and offense against the property. So these are three broad distinctions that the IPC had gone about. Offenses against the state would have everything like sedition, then so on and so forth, community offenses, everything. Offenses against the human body, again made distinction, offenses against females, one part, and offenses against the other person would be coming in a different chapter. Everything is retained. The whole only thing is that chapter locations are changed. So therefore that is one part. And offenses against the property, everything remains identical. So therefore, theoretically, it is the same principles, same logic, and perhaps rightly so, because this country has got used to 160 years of IPC holding the fort. So therefore, your ethos can't change overnight. You can make certain changes in the right direction, and perhaps, I think, wait for the time to introduce some other changes. So it's a good beginning which has been made by the legislature. There is one more idea which I must share with you. Up till now, we had certain kind of punishments which were prescribed under IPC, like death sentence, life sentence, then term sentences with rigorous imprisonment, with simple imprisonment, with fine, and so on and so forth, confiscation of property. They have added one more idea, which is community service. And I have found 4 places where community service can be an alternate punishment. And it comes in defamation. Now imagine in defamation, the punishment now is 2 years, or fine, or both, or community service. Now there are no guidelines given as to how much of community service. If it is 2 years imprisonment, do you mean to say 2 years of community service? What kind of community service? Is it something like Kar Seva in a Gurudwara? Or does it go beyond that? How much time in a day? 2 hours, 3 hours, 4 hours, 6 hours, or 8 hours? And what is the measure? Because if a judge were to grant 3 days of community service, that's going by the strict law, it is absolutely correct. So therefore, there are no guidelines when it comes to this logic of granting community service as a punishment. These are essentially at a very, very ad hoc level and purely left to the discretion of the convicting judge or the punishing judge. To my mind, that's also not a good idea. There should be clear-cut guidelines as to what is the measure. if you are giving it as an alternative to imprisonment, then how much of community service? Is it 1/3, 1/2, 2 times, 3 times? We should have some kind of principle coming forth through legislation, rather than leave it to individual judges going by their own discretion and their own ideas of what is fair and just. So therefore, these are some of the ideas which I wanted to share with you. Otherwise, according to me, it's the same logic which follows and becomes part of under a new nomenclature, except for these, some of the changes which I have placed before you. So the challenges before you, again the same as were there under IPC regime. The challenges will always be coming in different shapes, different forms. I indicated few of them as a result of MCOC and other legislation, what would be the scenario. So therefore, these are the challenges. Changes, according to me, not much, but there are 3-4 changes which are very welcome ideas, and that's it. Thank you so much.